Al, for having us here today. And thanks for the very warm intros. Chris and I are very pleased to be speaking with everyone today a little bit about what the lawyer's role is in a commercial transaction, specifically for on the purchase side, and how lawyers can help, maybe dispel some myths, how you find a lawyer, all kinds of that stuff. So our firm, Gowling WLG, is a large international firm. We have over 1,500 legal professionals in offices across Canada, from Montreal through to Vancouver, and offices throughout the world globally. So we've got offices in London, Russia, France, Belgium, all over the place. So just to say that when you reach out to any of us, and Scott McLeeman is registered as the advisor for Village Wealth, and we take a very team-based approach to our files. So please feel free to reach out to Scott, to myself, to Chris at any time after this if you need some help or have some additional questions following the presentation. But just to say that we do have this large firm with tons of experience. Chris and Scott and I are part of a bigger group of about 10 financial services lawyers. So Chris and I work in the mid-market space. So what that means is we help lenders. Most of our clients are financial institutions who are lending to companies. So whether that's for the purpose of getting some acquisition financing for a purchase, or they're buying a piece of real estate, or just getting some operating capital, we help the financial institutions put the paper in place to make that happen. And through the course of that, we also represent oftentimes the borrower corporation as well. And we're really happy to do that because we're always looking to build relationships with businesses that we can have long-term. Like I mentioned, it's a favorite aspect of law practice for me to become one of those valued advisors for our clients. So that said, although we are a big fancy law firm, we do lots of work in the smaller space as well. And I hope that we will be able to demonstrate that lawyers can be certainly friendly and approachable and not intimidating. And we're very normal people who are happy to help. So please, if there's anything you take away from this presentation today, I hope that that's one of the things. So to get started, we put together, this is just a slide of what we thought might be some preliminary questions that a buyer may have about seeking out a lawyer. And what we've identified as one of the biggest questions, and also what can be a big issue from our point of view, is when should you engage the lawyer? And I think Chris will agree with me that really there's never a time that's too soon. So don't be afraid to reach out to counsel or to start asking around for who you may want to call up a few lawyers and evaluate who you would like to choose. But oftentimes reaching out to a lawyer and having a very preliminary discussion about what your plans are for the business and what you want to do, it's often not a call that costs anything. Most of us, myself and Chris included, are very willing to have those preliminary discussions just to help a prospective new client figure out what they need, to help connect them perhaps with the right person in the firm, and to ensure that their needs are met. We both find that when we're working with a client from the very early stages of a transaction, the whole transaction moves a lot more smoothly than it would if we are getting a very panicked phone call that things have progressed down the line and closing is imminent and a lawyer hasn't been engaged yet. We'll be speaking throughout the presentation about why you need a lawyer and what the lawyer does in the purchase transaction. How do you find a lawyer? We can talk a little bit about that as time goes on, but basically word of mouth tends to be the easiest way to find a lawyer. You either have an existing relationship with a lawyer, or you have a friend or a business partner who has used someone that they can recommend. And of course, Village Wealth offers on their platform a number of recommended legal advisors, and you can certainly start from there. It's important to choose the right lawyer. So none of us are the same. We all have different practice areas. We come from different firms with different specialties. We're different age demographics with different personalities. And I think when you're looking for a lawyer, you want to look for someone that you can have a long-term business relationship with. It's not just a point of sale transaction where you use a lawyer and you're done with them. A lawyer can add a lot of value to your business beyond the point of the transaction. So don't be afraid to call a few lawyers, have a chat with them. Like I said, these conversations are often cost-free, and get a sense of their practice area. Someone who practices wills and estates is probably not going to be of much use to you if you are acquiring an ongoing business. So just make sure you ask the right questions, and we'll be talking more about what those might be. And a big thing that our clients, anyone using a lawyer is often afraid of is the cost of using a lawyer. Don't be afraid to have that conversation very early on with your lawyer about what their hourly rate is, what the estimated cost of completing the desired work is. We are not offended by having those conversations. We have them every single day. We're very comfortable having them, and it is a smart idea to have the conversation upfront rather than to be surprised when you get an invoice. So we put together this list of what would be sort of a typical deal timeline. So these items may not necessarily be in the exact order, but this would be a general flow of a typical purchase transaction. So there would be the initial contact between the buyer and the seller, some preliminary negotiations. Maybe the purchaser is going to a few financial institutions or discussing financing options with investors, other private equity options. So any time in those three preliminary steps would be a great time to get the lawyer involved. A lawyer can really help with preliminary negotiations because they know what the projected series of steps is in the transaction. And it's important when you're negotiating to always be in the position of power. And I think having a lawyer engaged early on will help you have a bit more power in your negotiating. The lawyer will help you identify items that would be very, very typically negotiated. You don't want to end up with a signed purchase agreement, then going to the lawyer and having to renegotiate certain material terms, maybe getting an amendment. You're really behind the eight ball at that point and you've lost your power. So getting a lawyer involved early does help you keep a power position with negotiating. After those preliminary discussions and maybe some firming up of the financing options, typically a letter of intent or a term sheet is entered into. This is something a lawyer can and should prepare just to make sure that all the material terms are captured. Often a letter of intent is non-binding except for certain provisions like the confidentiality provision. But again, it's a good idea to have a lawyer prepare that document so you understand what you are or are not bound to in terms of a letter of intent if things did fall through at one of the later stages of the deal. A lawyer can also then help, once you got your letter of intent signed, you're going to start doing some due diligence against the prospective business that you're looking to buy. So a lawyer will help here, and we'll go into that in more detail later on. If due diligence looks good, you're likely then going to start preparing the agreements as part of the transaction, and a lawyer, of course, would help draft and negotiate those agreements with the vendor's counsel. If the purchaser is obtaining financing for the acquisition, the lawyer would also be involved with the financial institution in preparing all of the documents that are associated with that and facilitating the disbursement of funds from the financial institution through to the purchaser and then out to the seller. There are some aspects of the transaction, this may not be intuitive, but there are aspects of the transaction that take place after the closing There could be working capital adjustments or an earn-out period. And oftentimes the lawyers are involved because there are funds held in the lawyer's trust accounts until all of these adjustments are settled and paid out. I liked this cartoon because it really drives home the point that buying a business isn't as simple as just handing over your cash at the till. There's a lot that goes on between those preliminary discussions and the point where either the shares are transferred or the assets are conveyed. So in the beginning, these are some more examples of how the lawyer could be beneficial to the prospective buyer. And so once you've got your deal sort of shaped up, you've identified a business that you want to purchase, and things are moving along with the letter of intent, some thought needs to be given to what is the most beneficial structure of this purchase. So whether that's an asset purchase or a share purchase, and those are highly negotiated types of transactions. So oftentimes a share purchase is more beneficial for the seller, and asset purchase is more beneficial for the purchaser, and at some point that it needs to be decided what the structure will be. An accountant should very much be involved in those negotiations and advice as well. A lawyer can help you incorporate a new entity, new company, if you're going to be purchasing the business through a company, and can help advise on some tax and liability items. Chris is going to speak a little bit in a few minutes about due diligence, so we'll just skip over that for now. And like I mentioned, lawyers can help you with your negotiating, and the sooner you can do that, the more power you can keep in the negotiating process. And as previously discussed, the lawyers can help draft the letter of intent. It's a really good idea to not go and pull a letter of intent from Google. There are, those are, like I mentioned, they're tricky because some aspects of the letter of intent are non-binding, others are meant to continue to be binding whether the deal proceeds or not. Often at the preliminary stage, there's also a non-disclosure entered into. So the vendor may ask that the purchaser sign a non-disclosure so that, and that would permit the purchaser to go in and do their due diligence without the world knowing, and very specifically without the vendor's customers and investors knowing. So we are often asked to review non-disclosures or to draft them, and for the purposes of this presentation, just know that that's something that the lawyer should very much be involved in and preparing or reviewing, depending on the needs. Then, of course, the agreement is drafted. There are a number of closing documents ancillary to the actual purchase agreement that the lawyer would draft. And it's important that all of those are prepared. If there's any employees of the prospective business that you're purchasing, advice from an employment lawyer is very important to get, because we have employment standards laws here in the province and in the country that treat asset and share deals differently, and provide for recourse of the employees depending on how they are treated in the purchase and sale of a business. And I already mentioned that if there is some bank financing involved, someone like Chris or I is likely going to be needed, where we are preparing paper on behalf of the financial institution and facilitating the disbursement of funds from the bank to the borrower, who would be the purchaser. Chris and I have experienced many clients who have been very tempted to make a shortcut through this process. And it is very unfortunate because often these shortcuts result in increased costs and delay, although they were meant to do the exact opposite. So some examples of things we've seen that are tempting, but we would highly advise against doing is, like I said, pulling a letter of intent, or worse, a purchase agreement from Google or lawdepot.com, scratching it on a napkin. Please don't do that. It is much more cost effective to seek out proper legal advice and get your agreement prepared properly. Like, although the price tag when you call up a lawyer to get a fee estimate on preparing these things, if you're not used to dealing with lawyers, the price tag may be shocking. Maybe it won't be, but maybe it will be. but I can almost guarantee you that the cost of trying to do this yourself and getting into a legal problem later on will be double, triple, exponentially more than if you just paid a professional to do it properly from the outset. It can also be tempting to just skip the due diligence phase. It takes too long, costs a lot of money, don't want to do it. Please don't do that either. That is, can, again, result in tons of costs down the road. You don't want to get to the point where you're going to ink the deal on the closing date and you realize that the seller had, I don't know, bank financing in place that they defaulted on or something, like there was a looming skeleton in the closet. You want to identify all of those items very soon in the deal process so that they can be addressed in a timely fashion so they are not a surprise when you get to the closing. And Chris and I, our worst nightmare perhaps, trying to close the deal without a lawyer. It is not recommended whatsoever. You know, back in the olden days, there were a lot of handshake deals. But again, that would skip everything we just talked about. So no due diligence, and no properly drafted agreements, and I can't even imagine the cost of landing in that type of a situation. So on that note, I'm going to hand it over to Chris to talk a little bit more about what exactly the lawyer does as part of the due diligence. And the legal diligence isn't all of your diligence, but these would be some examples of what the lawyer does. So take it away, Chris.
Thanks, Priya. Yeah, so the lawyer basically helps you understand, you know, what it is you're buying and if like the person or company that's selling actually has the right to sell that. So this involves investigating the business, including the legal and financial affairs, and basically determining what the value of the company is. So, I mean, you'd engage a lawyer and an accountant to, you know, review the books and make sure that everything is in order, and just to make sure that there's, as Bria said before, that there's no skeletons in the closet and you're not about to close the deal and you realize that, you know, the person who's selling it to you doesn't actually have the right to do it, to sell it, or that, you know, there's tons of financing, or the company's gone bankrupt or doesn't actually have the assets that they have. So, you know, in the same way that you would do a home inspection or a lien search when you're buying a house or a car, you want to make sure that you actually investigate the business and determine what issues are going on with the business, and, you know, how it can be fixed, or if there's any negotiation that needs to come from that in terms of what the business is actually valued at. So the scope of the due diligence required will be determined by the transaction. So, I mean, if it's a larger transaction, then there's going to be a lot more due diligence to conduct. And then the type of the transaction, if it's a share purchase, then you're going to want to make sure that the minute books of the company are all in order and the company actually has, you know, everything's up to date and the people who are assigning things actually have the authority to do so. And then if it's an asset purchase, you're going to want to make sure that there's no financing on that, there are liens, and the lawyer would assist where, if there was any liens, then those would get paid on the closing of the transaction. With financing, so that's kind of what Bria and I do mostly, is the bank, if the bank is going to lend a business money, then they're going to need to know that their security is in first position, and so they're going to engage the lawyers to conduct the due diligence. And if you bought this company or you're about to, and then you try to go and get financing, and then the bank comes in and they realize that, you know, the company has a loan with another bank, then they're not going to be able to lend you that money on the assets of the company. So again, there will be some things where there'll be a materiality threshold. So, I mean, if there's ongoing litigation against a large company to a large company, you know, a $10 million litigation might be nothing, but if it's a company that's only valued at $10 million and they have basically a litigation started against them that's basically the entire value of the company, then that's going to be a huge risk in buying a company with something like that going on. And then again, just the purpose of the transaction. So it'll depend on, you know, what the goal is. If you're just taking the assets of the company and you don't care so much about the shares and the structure, and if the company's books are all in order, then, you know, they're not going to need to conduct due diligence on that. But if you're looking to assume the shares of the company, then you need to make sure that everything's in order there. Do you have control of the next slide? Yeah, so as I said before, if you have your letter of intent and you kind of like come to your basic terms of the deal, and you say you want to buy a company for X amount, then you're going to want to conduct the due diligence to confirm that what you've assumed about the company is true. And then you want to determine if there's any issues that may decrease the value. And so there's tons of due diligence, and I'll get into some more examples on the next slides. But I mean, you want to conduct your searches against all the public registries, but then also reviewing the share structure and everything. And if there's, and this will aid in your actual drafting of the documents, because you can get certain representations in the agreements or warranties where if this potential risk that was uncovered during the due diligence searches comes true, then you could go back, and if there's a reps and warranties in the agreements, then you could structure that into the actual agreements where the you can maybe get indemnified for that. It looks like we have a question, and I'm happy to answer that.
Yeah, so Austin's asked, generally speaking, what can one expect to pay for due diligence? Is it based on the dollar value of the company or hourly?
So it depends. I mean, it will depend on the exact what's involved in the review. I mean, the lawyers would probably charge mostly hourly, but there's pretty much a set price for the majority of the searches that you would have to do. And then, so I'll get those into those on the next slides. And so like all the public searches, which if you're looking to buy a business, you might just not even know what types of searches that you would need. So a lawyer can help out with that. And they can give you, a quote on what the costs of like digging into certain searches. And some searches, kind of what Bree and I were saying, like if it's a large transaction, then you may not conduct all of the possible searches that you can do, because it's not going to be worth the cost associated with it. And you can live with the risk of like, oh, maybe there will be something down the road, but it's the risk of that is pretty low, versus a large transaction. You're going to want to kind of turn over every stone you can and make sure that there's nothing there. So in terms of, I think, generally speaking, what you would pay for due diligence it probably is more based on the value of the company. But if you're engaging a lawyer, then you're probably going to pay the hourly of them to actually review things. And it'll depend on if everything's good and there's nothing really to uncover, then it's going to be less. But if there are skeletons hiding in the closet, and then the lawyer has to basically uncover that and to rectify it, then it's going to be more expensive, but it's going to be better in the long run, because if you didn't do that due diligence and then you run into an issue down the road, then it's probably going to be a lot bigger loss than spending a little bit of money on legal fees. And then, so other due diligence we would do, basically we'd identify agreements that are affected by the transaction. So these would, if there's like a shareholder agreement, and where they would have to have like a unanimous shareholder agreement, and then none of the shareholders agree, maybe some people want to sell you the company, but the other shareholder doesn't want to, and then you would realize that the deal may fall through because those people don't have the actual rights. And then, yeah, so if so as I've kind of been thanks, as I've been talking about, so one of the major due diligence that you do when you do the Minutebook review on the target. So this basically confirms, the articles and bylaws would make sure that the company was properly incorporated. It would show who has signing authority on behalf of the company. So if they're selling assets, and maybe someone's just going rogue and they're trying to just sell the assets of the company, even though they don't actually have signing authority. So we would, review that, make sure that whoever's signing on behalf of the company has the actual authority to do so. If you're buying a company and you're buying shares, then you want to make sure that all their Minutebook is in order, and if those shares are certificated, and then you'd have to cancel those shares and issue new shares to the new purchasers, and so then they would become the owners of the company. So as I said before, the public due diligence searches, the lawyers know what kind of searches that you need to order and where those are available and who to get them from. And it's kind of, if you don't know any of that, then you don't know what you don't know, so you don't know which stones to uncover, and so a lawyer can aid in that. And then with the contract reviews, a lawyer will review your term sheet and letter of intent, and then when you actually go to drafting the contracts, you want to make sure that everything is included that you want to be included in there, and then there's no kind of funny clauses that were just included on the Google Doc that you pulled off the internet, and then you realize that you're about to sign something that's going to like really hurt you in the long run. So engaging a lawyer to do those reviews of the agreements is really beneficial and can avoid a lot of potentially harmful events down the road. Yeah, so I've said a couple of times, you know, just to confirm the corporate structure and governance for the entity in order as they've represented. If you're obtaining financing from a bank, then the bank is going to need to know that your minute book's all in order, and they're going to require an officer certificate, which basically certifies that, you know, your constituting documents haven't been amended and these are the articles and bylaws of the company. And then they're going to need an opinion from a lawyer to say that, you know, the company is validly still existing. So when you're reviewing the minute book, you would, you know, make sure that the articles and bylaws in order. You understand who is the directors and officers and who are the shareholders. You want to see that all these officers have been properly appointed, and if they haven't, then, you know, they need to do a resolution where like the directors would actually appoint the officers to manage the affairs of the company. And then you want to make sure that the company has filed all their annual returns and everything has been basically registered in the corporate registry. So that's kind of a brief overview of Minutebook. I think go to the next slide. So these are the examples. So these are the examples of some of the public due diligence searches that we would conduct when doing due diligence on a company. So the corporate search determines that the company is validly registered in the province in which they're doing business. And you can be registered federally or provincially. Most are just provincially registered. And then if you do business in another province, then those companies have to be registered extra provincially in each province they do business. So if the company is representing that they do business in all of these different provinces, then you want to make sure that they're actually registered to do business in those provinces. Again, the litigation searches, that's going to uncover whether there's any material litigation ongoing against the company that you need to dig deeper into. The personal property security search. You guys might have seen this before if you ever did like a lien search on a car that you're going to buy, and you search the serial number, and this shows you whether there's like any other person who's claiming an interest in this vehicle or whatever. Then the same goes with the company. You can research the name of a company, and if that company has granted security interest to someone, then that will appear in that search, and it'll show basically who has security over them. So there's a question that says, how often do you find companies who are trying to have minute books that are deficient or not up to date? All the time, like constantly. So,
or better yet, they don't have a minute book.
Yeah, like, and you're required to have a minute book, but if someone just goes to the registry and they say like, you can get a company incorporated, but your company has to have a minute book and it has to be like kept up to date. So it happens all the time. And then like you're about to close and then you're like, oh, well, actually your minute book's not up to date. So we have to do all these like resolutions and rectify the minute book before you can basically close on it, because the bank financing will require that. They need everything to be in order. And we have like an entire corporate services department that like just manages companies' minute books. So like you can hire a law firm to just like be the registered office and keep your minute book up to date and make sure that everything is good. And then you don't run into that issue if you're trying to sell the business. But yeah, it's a very, very common problem. So then the Bank Act search, that's just another kind of security search that's given under the Bank Act, which is a little bit more limited, and you don't see those types of, on the mid-market stuff, you don't see as much of that. The bankruptcy insolvency search, that's going to tell you if the company has ever filed for bankruptcy or CCAA proceedings. And then you would also do research on the directors and officers of the company, because if you're a bankrupt individual, then you can't be a director of a company until it's been like completely discharged. So you want to make sure that, you know, the company hasn't filed for bankruptcy, or the people trying to sell you who are like, yeah. Then the
question, Chris, sorry to interrupt. How much effort would a public due diligence search typically take?
Not like for lawyers who do it all the time. Like we have like clerks and like our office, because departments that kind of just do it, and that's kind of what they're used to. Some of the searches take longer to get back than others, but for these searches that are listed here, we'd get most of these back in a couple of days. And then, you could kind of identify those issues. Some of them with COVID, all the litigation searches are taking weeks to get back because the Alberta courts still use a paper filing system, which is a little bit dated. So you got to go physically like pick up they print off the searches. But yeah, no, these searches, most of them don't take that long, the public searches.
Okay.
And usually when we're quoting or financing, Chris and I often include the price of the due diligence in our quote. So it's certainly a question worth asking to the lawyer, is due diligence included? But oftentimes we just lump this in with all of the other work that we're doing because we as professionals wouldn't be comfortable drafting reps and warranties in an agreement unless we knew that our client could give them. And this running these searches would be part of that.
How long would a first-time buyer anticipate the due diligence taking?
I mean, it would just be a part of the transaction. The due diligence is usually not the thing that slows up the transaction. So it would not take very long. It would take a few days if you just wanted to order these searches. But I mean, sometimes there's issues that come up with them that need to be rectified. But the actual searches themselves should take a couple of days.
It may be longer on the accounting side, like reviewing the financial statements, or if there's real estate involved, like going out and doing site visits and inspecting the assets of the business, like that on the ground due diligence, which is also part of the due diligence, but not what us as lawyers do. That part takes longer, but that would be something that the purchaser is doing themselves. The legal stuff, it doesn't take long unless there are problems that need to be fixed. And often if there was something that came up through the course of these searches, we're discussing it with the client. There may be terms built into the agreement to address it. Like if the rep and warranty is that there's no outstanding litigation against the company, there may need to be a carve out if there was a motor vehicle accident or something showed up on the court hit. And rectifying a 60-year-old company's Minutebook could take more than a couple days. So it really just not often like a deal-breaking timeline. Usually due diligence is pretty quick, but the sooner you get on it, the better.
Yeah, because as Bruce said, if there are issues, those issues can sometimes take a long time to fix if you need to track some things down or people to sign stuff. But yeah, the searches themselves, they come back fairly quickly. We can go to the next slide.
Okay. Oops, sorry.
Yeah, so I touched on this earlier. This is kind of it ties into the due diligence because I mean there might be contracts that you need to review in connection with, like if the company is bound by certain agreements and you're going to buy a company, then you need to review those contracts and make sure that what you intend to do with the company isn't going to violate these agreements and you're going to get sued on them basically. So a lawyer, it's good to engage a lawyer to just kind of review the contracts because I mean some of them are standard boilerplate clauses in a contract, but the lawyers are the ones who know what is standard and what's kind of really odd to request in a contract, so they can review those and determine what needs to be done with that contract. So if there's any consents or assignments are required with the other parties to the contract, if you are basically buying a company or you're basically, if you depend on how you're structuring it, if that contract needs to be assigned and if the other party needs consent, or if a contract's not assignable, then you might not even be able to step into the shoes of that party. So these come to play in financing with banking and lending, the commercial contracts, if you are signing on to a franchise or a services agreement, if you're buying oil and gas leases, you want to make sure that they own the leases, and if there's any pooling or joint operations with respect to those. Employment contracts. So these are just examples of certain contracts that the lawyers would review to aid in the due diligence. That's good. Next slide. I think it's back to Bria now.
Yeah, so just to summarize some of the pitfalls that can occur if a lawyer is not engaged or not engaged until late in the deal. It's cost and time ultimately. So it can be more or less depending on how late the lawyer was involved or what was missed in the preliminary steps of the transaction before the lawyer identified the problem. But ultimately, it's always time and money is the cost of failing to engage counsel early. I think I had some examples here of what we mean by skeletons in the closet. We've referred to that a couple of times in the presentation. So some examples that Chris and I have run into as banks counsel when we're doing our due diligence against. So we do those due diligence searches that Chris just mentioned. We as lenders counsel do those against the borrower, very much like a purchaser would do against the target co. So we have flagged writs that are registered at the personal property registry against companies that maybe some of the companies claim they didn't even know about, although notice is required to be given when writ is filed. Writs can be filed. There could be a consent that was missed. Very often, tenants, businesses who are tenants and have a lease are not aware that if they go to sell, there is very often a consent of the landlord required, and that transfer provisions would be triggered under their lease. So they get to closing and someone like that guy like Chris or I is saying, where's your landlord consent to this transaction or this financing? And they're like deer in headlights, and they need money tomorrow, and we're telling them you've got to go back to the big landlord who does not move very quickly. That can become a big problem. Similarly, there can be consents required under service agreements or any kind of agreement really that the company has in place with its service providers or consultants or even employees. Oops. I was trying to click the question here.
Can you see it? I have it. It says,
yeah.
If you don't need to pay for a lawyer upfront, can the business lawyer be paid with equity of the business or after the deal is done using the earnings of the business?
So no, as lawyers, we have ethical obligations that would prevent us from doing that. We can be paid out of, if a customer or client is obtaining bank financing, the lawyer can be paid out of the proceeds of the loan, but we do not, we remain arm's length from the actual business of our clients. We do not give them business advice, only legal advice, and we do not get involved with their business, and we would have trouble with the Law Society or need to do some explaining. Actually, it would just be a huge problem to be paid in equity of the business. So full stop. But again, just planning, doing your financial planning, doing your budgeting. It's important, to have one of these cost-free calls with a client right away, or with a lawyer right away, to understand what the cost is so that you can allocate your resources appropriately. So if a lawyer is going to cost $5,000, maybe you're pulling from your budget in another aspect to make sure that does get paid. That's a good question. The lawyer does need to be paid upfront, and we can be paid out of not just loan proceeds, but the proceeds of the sale or any other cash that was coming in through our trust account to the client, and we do that. We obtain proper authorizations to do that. We never do that of course, without the consent of our client or anything like that. We obtain written approval to do that. But that is one, just kind of the obvious example that I can think of where the client doesn't have cash in their bank account per se. We haven't mentioned yet, but it is also fairly standard for lawyers to request a retainer up front. So a lawyer may say they need, $2,500, $5,000, whatever the amount is, to be deposited into the trust account before they even begin work, so that the lawyer has certainty that they're going to be paid, and then there would need to be communication with the client as the fees begin to approach the extent of that retainer. But Chris and I, in our world, because there's often a loan involved, we are obtaining a direction to pay from our clients and being paid out of the loan proceeds.
I have a question. Because you guys talk
Sure.
so much about like financing and loans, and you help guide buyers along that line. Sometimes when I'm talking to our village wealth buyers, they're not having that conversation early on about the financing part of the deal. And when do you guys suggest they start having that conversation, either with the lawyer or the financial institutions, or, when's the best time?
Yeah, as early as possible. And like Chris and I have a large network of banker, like customers, clients, friends, peers. So that's also a value add that the lawyer can add, is to help connect the client with a prospective banker who may be able to evaluate financing options. So we have contacts at all of the major banks, and that is something that I have and continue to do for clients, corporate clients who are looking to purchase a business.
Okay, thanks.
Do you have anything to add, Chris, to that? I think.
No, yeah, just early on, and then just, if it's just to reiterate kind of what Bria said, just to leverage your network. Like we're always happy to make an introduction to bankers or anything like that. And we have, working at a large firm, we have the access to, if I don't know someone, I know somebody who will know somebody. So it's, we're always happy to help with that aspect as well.
Cool, thanks.
Yeah, and so I guess just going back to finish off this slide, another pitfall that can occur from failing to engage the lawyer early is just the missed opportunities to negotiate. So again, going back to that, having power in your negotiations. If the deal's already been inked and the lawyer wasn't involved, didn't have the chance to have discussion with the client early on to flag some issues and some areas that should be considered for due diligence, whatever, pen's already been put to paper, the agreement's been drafted, you've missed the window there to negotiate. And like I mentioned in the beginning, it's very hard to negotiate an amendment to an agreement once the agreement's been signed. It's much easier to identify all the stuff at the beginning and to draft the agreement accordingly.
Do you guys typically handle the loan applications on behalf of a buyer?
No, so the bank will do that piece. And just very generally what happens is the customer, the borrower goes to the bank. They would go through the whole credit approval process with the bank. They enter into a credit agreement, and then the bank sends the credit agreement and instructions to us. So the lawyer's not involved until all the credit stuff has been approved. And from there, we are drafting the paper and facilitating the flow of funds from the bank through to the law firm, through to whoever it's going to, the seller, or if it's just operating capital, back out to the borrower. So the final slides, I just wanted to run through a recent example I had of exactly what we've been talking about. So my client was a bank, and I was also acting for a purchaser. The purchaser and the seller found their own form of agreement that was signed. The purchaser had not yet incorporated the company that they were going to be using to purchase. It was an asset purchase in this case. So they just signed the agreement using the name of what they thought was going to be the company. They went and got bank financing based on that. It turned out the name of the company was not available, so they had to choose a different name when they went to actually incorporate. The bank had to redo its credit agreement. We had already been engaged. We had already prepared all of the loan and security documents. We had to prepare them all over again. So added cost here for sure to this purchaser. The purchase agreement itself was a disaster. Like, there was arbitrary dates chosen that had already passed. The defined terms in the agreement didn't match. There was unused defined terms in the agreement. It had to be completely redone. I think continue this on the next slide. The agreement itself that the individuals had prepared themselves was not legally binding. So there are requirements to have a contract. You can't just scribble a sentence on paper and call it a contract. There are legal requirements. Consideration has to be paid. So that's whether that's notional or actual, like a $5 from me to you. There has to be consideration. There has to be intention to be legally bound. And in this case, the purchase entity, like I said, they just chose a name from thin air. It didn't even exist at the time that the contract was entered into. There was, needless to say, no Minutebook existed. So all of these documents had to be re-prepared. Very frustrating for this purchaser because what they thought was going to be their closing date had to be pushed out by more than a month. They incurred, I'm not sure what the exact dollar of the added cost is, but I'm going to say it's somewhere in the vicinity of $15,000 probably, all of which could have been avoided if a lawyer had been engaged very early on. So that's just kind of a real life example. It's just the most recent one, but we certainly have tons of examples like this. And we know, when you call up a lawyer and you get a quote for an asset purchase or a share purchase, those numbers can be intimidating. I think it's so important to understand what the costs are before you get very far into the whole process of buying a business. Just like, like buying anything, a home, a car, anything, it's just good to have the facts and to understand what the costs are going to be going forward and what the ongoing costs are going to be too, because there's you buy the business or you incorporate a company and there are some carrying costs, annual maintenance costs or filings that need to be made every year. So it's really important in your financial planning just to understand all of that.
When would you suggest that they get incorporated?
Yeah, so it really depends, but because there's a cost to incorporation and there is an annual cost to having a company. So the government requires you to file returns for your company every year. These aren't tax returns. These are just returns in order to keep the company in good standing. So you don't want to incur those costs. They're not insignificant. They're not huge, but I mean, I think like an annual filing is a few $100s, and an incorporation could be, $1,000 to $2,000. So you don't want to do that unnecessarily and just have a company sitting around. So probably closer to the stage that you're ready to put pen to paper and you're serious enough about buying the business that you're either going to the bank to get financing, or you're ready to enter into you don't need to have it at the letter of intent stage, but certainly by the purchase agreement stage you do. But yeah, so a lawyer could better advise, but certainly just know that there is a cost. So you don't want to just go incorporate a company for the sake of doing so, because that would be expensive.
We have a couple more questions, if that's okay to jump in.
Yeah, sure.
Okay,
yeah.
What's the most common mistake buyers make in the business acquisition process that you guys can help with, that lawyers can help with?
Do you want to take that one, Chris?
Look at his face. You're muted.
Sorry, I'm muted, sorry. I don't know about the most common, but I mean, just, the kind of what we've been saying on the whole presentation, the avoiding the not engaging. What's the most? I don't know the most common one, I don't think, but just like you don't engage a lawyer, so you don't uncover the things you should have, like with the due diligence. Your contracts are all wrong. Like the example Bria gave was great, but I can't think of like the number one most common thing that the buyers would do.
Trying to draft something yourself. Like I would say, like trying to draft stuff themselves, agreements, and not to slight the registries, but it's important to know that if you go to you can go to a public registry to get your company incorporated, or you can go to a law firm, and the registry is going to charge you less. But you need to understand that if you do that, they're not providing a minute book, they're not organizing the company. And chances are the articles of incorporation will need to be amended before your company does anything, because they don't include what we call the private company restrictions that abide by the securities law. So that's something we have to change all the time when we see a company that's been incorporated at a registry. So yeah, just that's a common problem we see too. If someone's just tried to save some money by doing something on the cheap and quick, and then it comes to us and we're like, well, it actually has to be done proper. So we're now going to have to probably charge you as much or more as you initially paid to get this done, to get it fixed.
We're coming up on our hour here, so maybe one more question, Giselle, and then Bria, if you have any more slides that you want to run through before signing off. And I know your contact information is at the very end as well.
Yeah, maybe I'll just skip ahead to that. So we've already talked a little bit about fees and having a call with a lawyer to discuss what those would be, and maybe a retainer is payable or not. So.
Great. Giselle, any more questions there?
Just one question was asked, can a buyer and a seller use the same lawyer?
So no, preferably not. The lawyer would be most likely in a conflict of interest. There's certain exceptions, but generally the lawyer who is representing the buyer should not represent the seller as well. And again, when we think about the power of negotiating, you want the lawyer to be acting in your best interest. So if you're the purchaser, how could the lawyer who's representing the seller, adequately represent your own interests? So we would definitely recommend that both parties, obtain counsel, because that's another common issue we see, is maybe the seller just doesn't want to go get a lawyer. They are getting offloading this business and they don't want to incur the cost, but that you get a lawyer, and two, that the lawyers are separate. So.
Wonderful.